Okay. My name is Joan Claude, Chair of the Libraries and Cultural Affairs Committee.
Yeah.
It's now 7:03 p.m. and this meeting is now called to order.
Muted? It is muted.
I am. Can you all hear me?
I can hear you.
Okay, thank you.
Yes.
Okay,
It is muted.
I'll open with a prayer. Dear Heavenly Father, we thank you for the opportunity to come together like this one more time, dear Lord, to meet, to discuss matters, and to receive information that will help us as we go forward with our lives. Dear Heavenly Father, you have given us so many different ways to serve. Some serve in giving, some serve in receiving. Dear Heavenly Father, whatever platform you have given us, help us to work with it in serving the people of our community. Bless everyone who is under the sound of my voice, dear Lord. Those who are on their way, please speed up their steps, dear Lord, and let us enjoy and receive this invaluable information that we will receive today. And I ask all of this in your name, amen. Welcome everyone to this call today. We're here to receive some invaluable information that will help us as we go forward with our planning in our life's situation. It's May 3rd. Every month, there are different causes to celebrate. And in May, we have a lot of different occasions. The most important one that's relevant to almost all of us here is Mother's Day. So today, we will pay tribute to mothers. I'm sorry this was not on the agenda, but I would be remiss if I did not mention something about Mother's Day. But first off, we have a guest speaker, Mr. Hugh Campbell. And at this time, I would ask Miss Sadie Campbell, no relationship, I understand, to introduce Mr. Campbell. Sadie?
Can you hear me?
Yes.
Yes.
Okay. Good afternoon to all. And I hope everyone is having a wonderful time. Okay. I will introduce to you a real gem of the Bronx. He's hiding among us, and he's a gem. His name is Hugh W. Campbell, attorney at law. And I will tell you a little bit about him. He's the past president of New York State Trial Lawyers Association, founding member and past president of the Black Bar Association of the Bronx County, the president of Bronx County Bar Association, and he's listed as New York Metro Area Super Lawyer from 2019 to the present time, representing clients throughout New York State. And so far, he has, I think, about 40 years of experience. He handles accident cases resulting in serious injuries and death cases. Mr. Campbell also specializes in real estate, wills, and general litigation. I say turn him to any cause of policy and in the legal field, and he will be able to loose all those guardian knots. I present you the gem of the Bronx, Mr. Hugh W. Campbell.
Okay, I'm sorry. Before Mr. Campbell goes on, I'm a little backwards today. I apologize. But let's do the Mother's Day tribute first, and then Mr. Campbell will have the floor to himself. Okay, so Mother's Day is an occasion which is celebrated in various parts of the world to express respect, honor, and love towards mothers. It is a day which makes people remember the importance and significance of mothers in their life and is observed as a day to give special emphasis to the mothers, grandmothers, great-grandmothers, and motherly figures all over the world. Happy Mother's Day to all the mothers, grandmothers, godmothers, and some men who do the work and step in as mothers. Short history of Mother's Day. Following Anna Jarvis's mother's death in 1905, she conceived of Mother's Day as a way of honoring the sacrifices mothers make for their children. Her persistence paid off in 1914 when President Woodrow Wilson signed a measure officially establishing the second Sunday in May as Mother's Day. That's a short intro of Mother's Day introduction. Now we'll have Miss A4 last. I'm sorry, A4 last. She will pay a tribute to mothers. A4.
Thank you. So I'm going to read a poem by Fred Cruz called Mother. Can everyone hear me okay?
Sure. Yes.
Yes, yes.
Okay. Mother by Fred Cruz. Somewhere between the youthful energy of the teenager and the golden twilight years of a woman's life, there lives a marvelous and loving person known as mother. A mother is a curious mixture of patience, kindness, tolerance, understanding, discipline, industry, purity, and love. A mother can be at one and the same time both love lore and counselor to her heartsick daughter, and a head football coach to an athletic son. A mother can sew the tiniest stitch in the material for that dainty prom dress, and she's equally experienced in threading through the heaviest of traffic with a large station wagon. A mother is the only creature on earth who can cry when she's happy, laugh when she's heartbroken, and work when she's sick. A mother is as gentle as a lamb and as strong as a giant. Only a mother can appear so weak and helpless, and yet at the same time can put that fruit jar cover on so tightly even Dad can't get it off. A mother's a picture of helplessness when Dad's around, but a marvel of resourcefulness when she's all alone. A mother has the angelic voice of a member of the celestial choir as she sings Brahms' lullaby to a baby held tightly in her arms. And yet the same voice can dwarf the sound of an amplifier when she calls her boys in for supper. A mother has the fascinating ability to be almost everywhere at once, and she alone can somehow squeeze an enormous amount of living into one average day. A mother is old-fashioned to her teenager. She's just mom to the third grader, and she's mama to the little two-year-old. There's no greater thrill in life than to point to that wonderful woman and be able to say to all the world, that's my mother.
Beautifully done. Thank you so much.
Lovely,
We
lovely.
know how important mothers are. A mother's love is unconditional, supporting her children through all situations. God bless mothers everywhere. Now, Mr. Hugh Campbell,
Mr.
your
Campbell
turn.
or Jem
Okay.
of the Bronx.
Thank
Good
you,
job.
and good evening, everyone.
Good evening.
Thanks for inviting me to share this evening with you. And I'm going to try to share a screen because I understand I'm going to be speaking on certain aspects of Will's estate and some related matters. So I'm going to try to share a screen so that you can just follow what I'm speaking about. Okay, I'm trying to share. Okay. Okay, I don't see it here. Okay, give me 1 second. Okay. All right, so today, let me just start the slideshow. Okay, so basically, you know, I was kind of asked to give some information regarding wills and estates, and I think especially now, this time of, you know, based what we see with the pandemic, a lot of folks are getting somewhat nervous because they realize that over the years they did not really put things in place. And by virtue of not putting things in place, I do get a lot of calls from individuals wanting to find out how they can get things done immediately, and how they can get things done in the right way. So I'm just going to be very brief, considering my time constraints, and just kind of say what we need to do moving forward. Now, basically, and I'm going to put my disclaimer up that the information contained here is for information only, and it's not legal advice. And I always urge you to speak to an attorney because many things are very complex and complicated, and I think it's always good to make sure that the attorney is addressing your particular issues and not just general information. So that being said, all the information I give you will be for general application purposes only. Now, normally when someone comes into the office and they say they want to do a will or an estate or estate planning or things of that nature, normally I would ask them some questions and I would say, do you have a will? Do you have a power of attorney? I would discuss guardianship with them. I would discuss a trust with them. I would discuss healthcare proxy. And I would also discuss life insurance policies because a lot of these issues are normally contained in, you know, getting information as to what an individual needs to do in order to set up their affairs and put it in order. So let's talk about, the person drafting a will. And one thing I will say is that in New York State, drafting a will, there's certain laws that apply to drafting a will. And keep in mind that, when a will is drafted, you have to follow those laws. And very frequently, I will see individuals that will come in and they will copy the format from the neighbor's will and they do their own will, or they will the child or the grandchild or somebody will jump on the internet and download the will, and then they do that and think that's their last will and testament. Unfortunately, if that document is not prepared in accordance with New York State laws, then the will is invalid, and that can create a tremendous amount of headache later on. So it's always important to make sure that the will is drafted properly. And as I said, there's certain laws which govern the drafting of a will, and those laws must be followed because if they're not, it creates more headache and it can be a very costly proposition. The second thing that I normally, and I'm going to get into more details, but I just want to kind of give you a highlight. The second thing that I normally discuss is a power of attorney, because very frequently folks come in and you talk about a power of attorney, and they never really think about a power of attorney when they come into the office because they figure that if they do a power of attorney, they're giving up their rights to act in a certain, on their own behalf. And I always caution the client because I said, in order to draft a power of attorney, you must have the mental capacity in order to draft that power of attorney. And if you do not have the mental capacity, then you will not be able to draft a power of attorney. So when is the best time to draft a power of attorney? When you have the mental capacity. Therefore, when you come in for the will, you say to the client, draft your power of attorney now, put it someplace safe so that when it becomes necessary for it to be used, at least it will be already drafted. Because what happens very frequently? Very frequently, I'll get a call from someone, Mrs. Jones or Mr. Jones is in the hospital. They need a power of attorney right away. They need it yesterday. And my question will be, okay, fine. Are they in a position to understand what is going on? And the answer will be no. They're on a ventilator, they're on some other type of device, and they do not have the mental capacity. If they do not have the mental capacity, then my response will be, I'm sorry, but we cannot draft a power of attorney for that person lacking mental capacity. So that's why it becomes important to have the power of attorney drafted when that person has the capacity and is knowledgeable as to their surroundings and what is going on. Now, if the person lacks the capacity to draft a power of attorney, then the next step will be a guardianship proceeding. Because when you draft a power of attorney, basically what you're doing is you're saying, I'm choosing who I want to handle my affairs in the event I cannot handle my affairs for myself. So you're choosing that person. And if you do not choose that person, then the court's going to choose that person for you. And that's where the guardianship comes about. Because if indeed you lack the mental capacity to draft a power of attorney, then someone would have to petition the court on your behalf, and you would need a letter from a doctor basically stating that you lack the ability to understand your affairs and to take care of your affairs. And then the court now would set up a hearing, and they would appoint a court evaluator to go and to speak with you and to evaluate you and to make a determination as to whether or not a guardianship should be appointed for you. And if a guardian is appointed, that guardian could be anyone. It could be an agency, it could be another attorney, it could be a total stranger, or it could be a family member. So keep in mind that once you don't have a power of attorney, it's the court that comes in and determine who should act on your behalf. And that's somewhat of a costly proposition because now you have to go to court, you have to file a petition in court, you have to get documentations from your doctors, and many times the court might require that the person who acts on your behalf might have to post a bond to protect your assets. So it's always important for you to choose who you want as opposed to having the court choose who they think is best for you. And normally when someone comes in, they might say, okay, I want a trust to be set up because I don't want my assets to go through probate. And in that regards, you would just set up a trust and then all your assets would be placed in a trust. And a lot of times that is used for when folks need to qualify for government benefits, and they would prepare what we call an irrevocable trust, because the irrevocable trust basically means that you have divested yourself of the assets and you have no say-so as to what you own anymore, but you still benefit from it. And in that particular instance, if indeed you have to apply for government benefits, there's a 5-year look-back period, whereas if you drafted the trust today, then 5 years from now, you would qualify for government benefits. However, if you had to apply for benefits less than 5 years, they would prorate it to a certain degree to make up for that 5-year period. So again, that's where the trust would come into play. The other very, very important aspect that I would discuss with the client would be a healthcare proxy, because again, if indeed someone had to make medical decisions on your behalf, that person would need a healthcare proxy. And many times folks will confuse a power of attorney with a healthcare proxy. No, your power of attorney is not your healthcare proxy, and that particular person who is your what we call agent under your power of attorney is not technically authorized to make medical decisions on your behalf, and that's where the healthcare proxy comes into play. So you would need to designate a healthcare proxy, which is someone who would make medical decisions on your behalf. And that is another form that I normally urge the client to prepare and to get that document to their primary care physician, because very frequently I will get a call from someone saying, oh, did Mr. So-and-so or did Mrs. So-and-so prepare a healthcare proxy? And the reason why I always tell my clients to give it to their primary care physician, because they are normally the first go-to if someone gets hospitalized and they cannot locate that information. Next thing that I would normally discuss with them is life insurance policies, because I always ask them to do an inventory of their life insurance policies. Why? Because many times, we'll have clients come in and they took out a life insurance policy 10, 15, 20 years ago, and they had beneficiaries on the policy, and they never really updated the policy. So I always say, go back and look at your policy. Who are your beneficiaries? Is it your spouse that you divorced, 20 years ago, or you've been separated from 20 years ago? You might want to update it. Is it someone who is predeceased or someone that you no longer would like to receive the benefits under the policy? So it's always very important to do a checkup with respect to your life insurance policies so that it'll be as up to date as possible in terms of beneficiaries, and make sure that everything is in place, because many times folks just buy the policy, they store it away and never look at it again. So let me just go over some of the basics of the will draft and an overview of will drafting. And the will drafting has changed somewhat since COVID-19, because normally when you draft a will, that's a relationship that you have strictly with the individual who wants to draft a will. And I say that because that's something that unfortunately we get a lot of pushback on, because when a client comes in, they want to draft a will, and somehow there's always a family member that insists on coming in with them. And I always try to explain to them that no, this is between the attorney and the client only, attorney confidentiality. So a family member coming in really doesn't, could affect the validity of that will. And why does it affect the validity of the will? Because from time to time, there is a possibility that will could be challenged. And if the will is challenged, you want to make sure that will is drafted as properly as possible and under proper circumstances so that it would withstand a challenge. Now, the reason why I say meeting and COVID-19 is because before COVID-19, we would normally just bring the client in, and you're in a room exclusively with that client. So you actually controlled the environment. Now it is somewhat different because we meet with the client remotely. So when we are on, Zoom or Teams or something else, or the telephone, we don't know who else is in the background. So that could create a problem in terms of if there's a subsequent challenge to the will. And that's something that I think we all try to grapple with, because one of the things that we will ask the client who is present, and sometimes when you have that discussion with the client, even if, and especially when you get in with elderly clients, because if you wanted to interview an elderly client, they will need some type of assistance, setting up Zoom or WebEx or something of that nature. But once that's done, then the other person should leave the room, because I'm going to ask who else is in the room with you, because that's something that we have to ask. And once you get the information from the client, then you're going to draft the will. And normally what we would do, we would send the draft out to the client, and then the client would basically review the draft, and they will call back and they would say, hey, these changes need to be made, and and this is who I want to leave out, this is who I want to add, whatever the case might be. What happens very frequently, and this is another problem that we have, is very frequently I will get a child or a grandchild or somebody who will send me an email, and they will say, here is my mother's last will and testament, the corrections to my mother's last will and testament. And what I have to do is I have to have my secretary call them up and say, no, I can't do that. I'm not going to open the email. I'm not going to look at it, because I cannot take information from a third person. Because once I do, it taints the validity of the will. And so that now creates a problem. And I think, it's very hard sometimes to explain that to the client, especially when you have the family members in close proximity, because many times they don't really understand. And when you try to explain it to them, they don't really, I don't think they grasp why we say we can't do it. So what we do is that we explain to them why you cannot be on the phone, part of the Zoom conference, or in the room when we're discussing the will with the client. And I'll tell you why that creates a problem. Because in the state of New York, when a person drafts a will, that will is deemed to be a legal binding document, except if you can show that there was undue influence, fraud, you know, overreaching, and then the person lacked mental capacity. So normally when a person would come in, we're going to talk to Mrs. Jones. I've known Mrs. Jones for years, and I'm going to speak to you. How you doing today? Tell me about everything, and I'm going to get all the information that I need. So I can evaluate that person's mental capacity based on the questions that I ask. Now, so that would basically get out of the issue of whether or not there's mental capacity. Fraud, that's not an issue because we follow certain protocols, so there's no need for fraud in terms of drafting. Now, where the problem comes in when family members get involved is when you get into undue influence. Because now, if someone is in the background while I'm interviewing Mrs. Jones, then there is a good possibility that person in the background could have exerted undue influence on Mrs. Jones. So that now creates a potential problem. So very frequently, even when I'm having in-person meeting, when I used to have in-person meetings, I would have family members who would come in and they would get very indignant that they wanted to be present in the room while I'm having a conversation with their parent about what they wanted to do. And normally, I try to be as polite as possible and tell them that they can't be in the room, and I tell their parent why they can't be in the room, and they will still insist until I tell them. I said, look, I'm gonna be very honest with you now. I says, I have not spoken to your mother. I don't know what your mom is gonna say. But I'll tell you right now, if for any reason your mom wants to give you anything more than she's giving the other children, you're jeopardizing it right now because that will is going to be thrown out because you were present in the room. And normally they get the message, they get up, they leave immediately because they understand that their presence could be construed as undue influence. So that becomes important when you're drafting the will to make sure that no one else is in close proximity because frequently, as the drafter of the will, I have to appear and be deposed as to what procedures I used to draft the will, who was present at the time of the drafting of the will, and based on the testimony, then the court might decide whether or not they're going to admit the will to probate or whether or not they're going to throw the will out based on undue influence or improper influence. So that being said, it's always important for the family members to understand that one person or two individuals cannot come in and have anything to do at all with the drafting. At least once you go to the attorney's office, because once you go to the attorney's office and you exhibit those criteria, then you create a problem with respect to the integrity and the validity of the will. Same thing goes for the execution. So because of COVID, that kind of made it easy because of COVID, we tell all the family members that now you can't come into the office. You have to stay outside. So when you do come in, so even if you brought your parent to the door, you have to stay outside because only the parent can come in, and then we'll have a very quick sanitized execution. Everything is notarized, put together, and then the parent would leave with their will in place. And normally, when the will is drafted, we would give the individual two options. You can leave with your will in place, or you can leave it with the attorney for safekeeping. And there are different reasons why we say to leave it with the attorney, because God forbid something should happen to you and the wrong person found the will and realized that they were not provided for in the fashion they thought they were going to provide it for, they can destroy that will and then so that they can get more. So I always said that only the original will be submitted to probate. So if someone found a copy and decided to, do something with the copy, it's really not that relevant because the original is what would be admitted to probate. Okay, so the question normally that I get is, does everyone need a will? And sometimes, people say, oh, I need to come in and draft a will. And then I'll sit with them and I said, you know what, you really don't need a will. And they said, but my neighbor or everybody on the block says I need a will, I need to draft a will. I said, don't waste your money because you don't need a will. So why wouldn't we need a will? Why wouldn't everyone need a will? So let's say, for example, Mrs. Jones, basically all she had was, 2 bank accounts. And on those bank accounts, she had 2 children, and on the bank accounts, she had the children listed and/or are in trust for. Now, if you have your children listed and/or in trust for, you're not going to draft a will to give them what's in the bank account, because the way how the bank accounts are set up, that's going to automatically go to them. So do you need a will to dispose of your bank account? No. So don't waste your money and draft a will. If you're an only child, or you got 1 or 2 children or 3 children, and the parent comes into me and says, you know what, I got a house and I want my 2 children to inherit the house. And I'll say, don't waste your money and draft a will. Why? Because that house is going to go to your children by operation of law. So you don't even need a will in order for the children to inherit the house. It's going to go by operation of law. So the only time you really need a will when you own a house is that you probably may want to come in and say, okay, well, one child is going to get 55% and one is going to get 45%, because sometimes you'll come in and say, you know what, I already bought the one child a house, so I'm not going to split this one equally. I'm going to give 155, 145. So you need a will in order to make that distribution. So based on that scenario, yes, you'll need a will with respect to your real estate. The other thing is that you may have a child who is disabled and receives government benefit. You may want to draft a will to make sure that child doesn't inherit anything. So you put everything in trust for that child, because once you leave everything to that child, then now they will lose their benefits. So you will need a will to provide for that particular scenario. Or you might want to come in and say, you know what, nah, I don't really trust all my children. So I'm going to direct that the property be sold and the proceeds be divided amongst all of them. Because I will tell you, it never fails. There's always one situation where one child's still in that house and they're going to stay in the house forever. And they're the ones who normally don't pay rent, don't pay mortgage, don't pay taxes, don't pay anything. And normally they will run the house into a situation where it goes into foreclosure. So you want to give someone the authority to sell, so they won't come in and say, oh, mom or dad didn't want the house to be sold, and then they sit there forever and never pay anything, and then the house goes into foreclosure. At least the will say the house has to be sold and the proceeds divided according to the will. Other thing that comes up, and one thing I'll say, and we have to keep this in mind because this is very, very critical, comes up all the time. One person, when you draft your will, there's one person you cannot disinherit under New York state law, and that is your spouse. So no matter how long you've been separated, as long as that person is your spouse, they have a right to come in and make a claim against your estate. And you cannot disinherit your spouse. So the first thing that one will say is that if you are still married, that person will have the first option to be appointed the representative of your estate. And that person will have what they call in New York State a right of election against your estate, because they're entitled to the first $50,000 plus 1/3 of your estate, and then it will be up to the other individuals to come in and say, nah, they've been separated. Well, they abandoned each other for X amount of years, but as long as that person is still your spouse, they have a right to come in. And one of the issues that comes up very frequently, and it's a matter of confusion because people have a tendency to confuse these two issues. Keep in mind that when you pass, your spouse is entitled to 100% of your estate. Does not make, when I say they're entitled to share in 100% of your estate, and it doesn't make a difference whether or not you bought that house 100 years before you got married. Because sometimes people are coming and say, well, but I had the house before I got married, so why should my spouse share in it? That only applies in a divorce. That's strictly matrimonial. So if you got divorced, then you can say to the judge, my spouse should not share in that because that was property that I owned before I married my spouse. But in the case of death, the spouse is entitled to share in the entire estate, irrespective of when you acquired that property. So keep in mind that you cannot disinherit your spouse. And sometimes it's very hard for me to tell some folks, but I said, you know what? If that's what you want, you might want to just go out and get a divorce, even though I shouldn't be advocating divorces, but that's the reality. Okay. Jointly held properties. Again, if you had a bank account and it was held jointly, if you had 3 children, but you had one child's name on that account, that child is going to get 100% of that account. So don't come in and say that child was only on there for convenience purposes, because as long as that person's name is on the account, they're going to get 100%. So what you cannot do is that you cannot draft a will and give money in a joint account when that joint account is going to go to somebody else. And the same thing goes for a house. If you own a house and you have a child's name on that house, you can't draft a will given that child's interest, because don't come in and say, oh, I only put that child's name on it for convenience purposes and they didn't put any money in. Nope, that's not going to fly, because they're technically by law the joint owner of that property, and you cannot give something that is owned by somebody else. So if you transfer half of the interest to your child, that half interest belongs to your child, and the only thing the other children will be able to share in will be hypothetically the 50% interest that you own in that property. So I want you to keep that in mind. As I said, real estate, condominiums, and co-ops, those go by operation of law. Co-ops a little bit different. Real property and condominiums, those goes by operation of law. Co-ops, you would have to go to court and have the court issue letters of administration or letters testamentary in order for you to dispose of co-ops. Co-ops are a little bit tricky because you always have to keep in mind that you technically may not want to give a co-op to someone, because the person who receives the co-op would have to qualify, by the co-op board in order to move into that facility. And many times that's always a very, dicey, iffy situation. So normally you just ask that the shares in the co-op be given to a particular person, and if they get in, fine. If they don't, then they liquidate the shares and they move on. But real estate, condominium, and co-ops, those are properties. The co-op you would leave in your will. Real estate, condo, you'd also leave in your will, or they can go by operation of law. If you die without a will, there's a certain set of law that comes up, and that is the EPTL, Estate Powers and Trust Law, and basically what that means is that who will get under your estate. So if you die without a will, the person with the first priority would be a spouse. Second would be children. No spouse, no children. Then it goes to brothers and sisters. And always keep in mind that if you have predeceased children, then it would go to the children of the predeceased children. Something that I also have to mention, because very frequently individuals will come in, and we find it happening frequently, is that people will come in and they say, oh, I am the daughter of so-and-so or the son of so-and-so. The only daughter or the son that you have is a natural born child or a legally adopted child. It doesn't make a difference whether or not you raised that child from they were, 2 days old. As long as they were not legally adopted, they're not considered the child, no matter what the will says, no matter how they were referred to. And we find that a lot because individuals come in and says, oh, I would live with this person all my life. That doesn't make a difference. You still won't have a right. Only a will would be able to give you benefits if you fit under those circumstances. And also keep in mind, and I think this happens very frequently, and it's something that occurs where husband and wife may own property, wife dies, entire estate goes to husband, and then husband dies. Now, frequently the wife's family will come in and says, "Oh, I'm entitled." No, 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 no. You're not entitled to anything because under the will, I mean, under the laws of intestacy, everything goes to the husband. It's the husband family now that has a right to come in and claim against the husband estate. So many times what will happen is that we will get individuals that will come in, and these will be individuals, let's say, married late in life. One had one family, one had another family, and they want to draft a will. So basically, I would say, look, you need to draft a joint will. And what does a joint will accomplish? A joint will basically says that up on the death of the last person, this is how the assets will be distributed. The assets will be distributed, meaning that the wife's family will get some, wife's children will get some, or the husband's children will get some. Both will share at the end, as opposed to one say, well, who outlived whom, and that person's family would get everything. And basically, what we would have is a provision that says that the first person who dies, their family would get, the survivor cannot revoke the will, because that's something that the survivor can do and said, you know what? I'm not even going to follow what my spouse said. I'm going to give it to whomever I want. But because you have a binding will, most you cannot go in and says, I'm going to change it, because the will specifically says that after the first person dies, the second person does not have the right to change that will. So that way you can provide for two sets of families, and it's not just one family coming in, because it happens a lot. It happens a lot where you'll find one spouse probably had a house and first wife died and they married the second wife, and now that that particular spouse died, the second wife inherits everything, and then the second wife's family comes in and take everything. That creates a very, very hostile environment between the two sets of families. So in order to avoid that, we suggest going in and getting a joint will. When is the best time to oh, one thing you'll see up here, because everybody will say, well, the state takes everything. The state doesn't take anything. Basically, if you don't have a will, it will go to your next of kin down the line, whether or not it be brothers, sisters, nieces, nephews, et cetera, et cetera. The state doesn't take it. Normally, what will happen if you cannot find anyone of that nature, then it will sit in the controller's office until someone comes to claim it. The best time to draft a will is when you're healthy, because at least you know what's going on, and you're not doing it in a rush, because normally when a will is drafted in a hospital or a couple of days before the person dies, the court normally question whether or not the person had the mental capacity to draft the document. Okay, I already basically said who you can leave your property to, anybody at all. The only person you cannot cut out is your spouse. You can leave it to your cat, you can leave it to the dog, you can leave it to Salvation Army, you can leave it to anybody you want, but you cannot cut your spouse out. So that's the only thing that we have to keep in mind, is that you cannot disinherit your spouse. Now we have small estates, and normally a small estate is considered an estate that is less than $50,000. So if you have an estate that is less than $50,000 and you are a distributee of the decedent, you can normally go down to the courthouse and fill out a petition. And I think the filing fee for that, I think it was like $1 or something like that. And as long as everybody who is your brothers and sisters of all the next of kin, and you can produce funeral bills and things of that nature, then they will issue small estate certificates, and you can just collect the money, and then you file a form with the court showing that you collected the money and how you dispersed the funds. Now, anything over $50,000, if there's a will, then that would be a probate proceeding. If there's no will, that will be an administration proceeding. And normally how it works is that, and this is another big, myth out there, and I always repeat it, that's not true. There's no such thing as a reading of the will. Okay? No such thing. So people very frequently will call and says, when can we set up to have a reading of the will? There is no such thing as a reading of the will. Normally what happens when someone passes, the executor who is listed in the will hire an attorney, and that attorney would complete all the necessary paperwork, and they would have those paperwork signed, notarized, and they would file them with the court with the appropriate fees. And if someone is listed in the will, those individuals would receive written notice and a copy of the will, and they can come to court and either object to the will, and that's when they would come in and object and say the person who signed the will did not have the mental capacity, or there was undue influence or things of that nature. And if there's no objection, then the court will admit the will to probate, and basically the estate would be, whoever is appointed the executor of the estate would collect all the assets and distribute the assets in accordance with the last will and testament. So if it's an administration where there's no will, the same thing would apply. The attorney would complete all the necessary paperwork, and many times what would delay the process is that, we have to get the names and addresses of all the next of kin, all the children or the children's children, and if indeed we cannot find them, or if they don't respond, then citation would have to be served upon them. And if we still can't find them, in order to serve citation, then publication would have to be done against them. And that's one of the most expensive part of this process, is publication, because many times for you to publish in the newspaper, the law journal, it costs anywhere upwards of $5,000-$6,000 to do publication for court purposes. So it's always important to try to get the names and addresses of all the individuals that are related to the decedent. That being said, what we do is that we always try to develop a family tree while the person is alive, so they can tell us, who are your next of kin? How many brothers and sisters did you have? How many children do you have? How many children predeceased? And we normally get all that information because sometimes when, especially now, someone lives to be like 100, it's very hard to find contemporaries that can verify this information for them. So we get it directly from the client, and we have them sign an affidavit, so that we use that as a family tree, because the court will very frequently ask for a family tree to see who is who and who are the actual next of kin. Okay, so one of the things that normally will come up after someone passes is that the person will says, okay, fine, what is your obligation after death? Technically, there's no obligation until someone's appointed the representative of the estate, because you don't have the authority to act on behalf of the estate. So even though you might be doing certain things, like someone will say, you know what, the light bill needs to be paid. And I says, okay, pay the light bill, because you need the lights to be on if indeed you intend to clean the place out and to sell the place. Pay the Con Ed bill, pay the cable. You don't necessarily need cable, that can be shut off. Your taxes, if you can afford to pay the taxes and afford to pay the maintenance, you pay those, and then you get reimbursed at the end. Once the estate is administered, you're a creditor, so you'll get paid as a creditor from the estate. The petition, and I already explained that with respect to hiring the attorney to complete the petition and file it with the court. In terms of who can petition, family member can petition, children can petition, or if you're a creditor, you can indeed petition. Anyone who is listed in the will as the executor, that's the person who will petition the court for letters testamentary. And normally when we draft a will, we will get an executor and an alternate executor. In the event the executor cannot act for any reason, then the alternate would step right in. So we would have the executor would be listed in the will, and if there's no will, then the family members can actually decide amongst themselves, or you can just initiate a petition and have everyone served in order to get the matter moving. There's always a filing fee for the estate, and that's filed with the court at the time the petition is filed. And as I mentioned before, waiver, citation, publication, those are processes that you have to go through in order for the court to appoint someone the representative of the estate. Guardian ad litems, if there are children involved, the court may appoint a guardian ad litem to protect the interests of the child, or if there's anyone under a disability, the court may appoint someone to protect the interests of the person under a disability. In the case of a will, normally the will say that no bond is required for the person to serve, but in the case of an administration, sometimes the court may require that the person who puts the application in to be appointed the representative of the estate post a bond. And that becomes problematic from time to time because we do have individuals who apply for letters of administration. The court will grant the letters of administration, but you have to keep in mind that sometimes the bonding company is not going to bond you if you don't have good credit, if you have bankruptcies and things of that nature. So if you can't qualify for a bond, that may prevent you from being able to serve as the administrator of the estate. And also, just to keep in mind, because this is something that we run into from time to time, is that in order for you to be appointed an executor or an administrator, you should not have been convicted of a crime. Because if you were convicted of a crime, you're not qualified to serve as a fiduciary in New York State. So you have to keep that in mind before you submit a petition to be appointed an executor or an administrator of an estate. All right, power of attorney. I already went over the power of attorney, what it is. And keep in mind, if you don't already have a power of attorney, June 13th, 2021, there'll be a new power of attorney that's coming into effect. They just passed new legislation to modify the current power of attorney so that on June 13th, there'll be a new statutory power of attorney that will take effect. So you can, if indeed you're going to draft one, then you might want to say whether or not you can wait in order to get the new power of attorney. One of the issues that comes up very frequently with powers of attorneys, and I think this new power of attorney that was just passed by the legislator addressed that issue, because many times you will go to a bank and the bank will say to you, here, sign our power of attorney. And that creates massive confusion for the everyday citizen. And why does it create confusion? It creates confusion because if you went to say, HSBC, and HSBC had you sign a power of attorney, that power of attorney is only good at HSBC. It is not good at Chase. It's not good at Citi. It's not good at any other institution. And that normally, kind of puts the person who's issuing the power of attorney into that false sense of security, feeling they have a power of attorney, not knowing that their power of attorney is not valid beyond the walls of their bank. So what we've been pushing for, and I think the legislator finally listened and passed the law, that the bank cannot have you sign their power of attorney. They must accept the statutory power of attorney, and that's the only power of attorney that will be valid moving forward. Because again, many times the banks will have the person sign the power of attorney, that person becomes disabled, cannot take care of the affairs, and says, oh, child comes in, oh, mom or dad had a power of attorney, only to realize that the power of attorney they signed was with a bank and is useless outside of that bank. So bank power of attorneys, be very careful. Look at your power of attorney. If it's issued by a bank, get yourself a general power of attorney that addresses all institution and addresses all aspect of your life and not necessarily your banking transactions. Okay, again, you always want to, I always suggest that you grant as broad a power on your power of attorney as possible, because some people come in and say, I want to give a power of attorney, but I only want to give this little bit of power. And I always say to them, well, you know, if you only give that little bit of power and something happens to you, the power of attorney is technically useless. So what do you want to do? You want to get somebody that you trust, because you don't want to give up power. If you have to worry about the power that you're granting the person, that means that you have reservation about that person. So you want to get a power of attorney to someone that you trust, and you want to give them as broad a power, because again, at the time that power of attorney is needed and the things that is needed for, you may not have granted that power, and that power of attorney is useless. Because in the power of attorney, you have to designate what power you're given to your agent to act on your behalf. So keep that in mind when you grant the power of attorney. Pick someone that you trust and give a broader power of attorney as possible. And again, that power of attorney, keep it in the bottom of your drawer. Don't give it to anyone until it becomes absolutely necessary for them to act on your behalf. And sometimes you might even say, you know what? Take this downtown, take care of my business for me, and bring about my original, because only the original power of attorney, would be valid under those circumstances. How long does the power of attorney last? It lasts as long as you don't revoke it. So if you have a power of attorney and you, for whatever reason, you drafted a new one, but the banks or any place else had the old power of attorney, you need to make sure you send them a revocation of that power of attorney, which basically is saying that do not honor this power of attorney anymore because it has been revoked. So you have to keep a list of every place that you share that power of attorney with, so that when it's time for you to revoke it, you can send them a revocation of the power of attorney. Statutory gift rider, that basically says that your agent that you select in your power of attorney can make gifts to family members, and that came about back in, I said, 2009, 2010, because what they wanted to make sure that, if indeed you had monies to gift, that your agent could gift the money to family members, because if they didn't, then there was always the issue of an agency coming in and says, oops, here is money, we want to take the money. So I guess the legislator figured it would be better for the family member to benefit from the money than to some other agency to come in and take it in order for you to qualify for benefits. Okay, I already discussed guardianship. That's a cost to proceed in. If you have a power of attorney, you really can avoid guardianship. And normally when you apply for guardianship, you can apply for guardianship of the person, meaning someone who would make medical decisions on your behalf, someone who will decide where you live and things of that nature, or you can apply for both, or you can apply for guardianship just of the property, which means that you have the mental capacity, but you just can't get around to take care of your affairs. You have the mental capacity, but you're not writing your bills on time, you're not balancing your checkbook, house is being you're not paying your mortgage, or you're not paying your maintenance, and the court will says, okay, fine, you have certain level of mental capacity, but we need somebody to help you, so we're going to appoint a guardian of your property just so that they manage your property for you. And that's the two areas of guardianship that you can have. All right, we discussed trust in passing, and I'm not going to get too deep into that. But let me see. We discussed the healthcare proxy and what you should do in terms of your healthcare proxy. So I don't need to really go over that again. And at the end, you're going to ask any questions you have regarding these topics. Life insurance policy, we discussed that. Oh, let me just address one thing regarding life insurance policies. Keep in mind that if you left the life insurance policy in the name of someone, that person has no legal obligation to use that life insurance policy to bury you. Keep that in mind. So many times someone will say, oh, I got a life insurance policy to bury me. I says, okay, fine. How is the life insurance policy drafted? It is left for Mary Jones, because frequently I have seen where the person is the beneficiary, They grab the death certificate, they go down, they take the life insurance policy, and they go on about their business. And they don't pay for anything because they have no legal obligation to do it. So your life insurance policy must clearly indicate it's for your funeral services, and it must name your estate as the beneficiary, not an individual. Because if the individual is listed, that's the individual that owns the policy, and not and it's not earmarked for any burial or anything of that nature. So I want you to keep that in mind when you take out your life insurance policies and you designate what it's for, because that happens very frequently. And I always say the person died rich, had a lot of money, but because they had all beneficiaries, they could not afford a funeral. That's because everyone is looking at each other and say, well, I'm not using my money. I'm not using my money. And then there's a big standoff. So make sure that you have the policy clearly spells out that it's to the estate and it's strictly for the purpose of burial. Okay, thank you. Any questions?
Yes, this is Toba.
Good evening, Mr. Cooper. How are you?
Can you hear me? Good evening, sir. How are you?
Very
Thank
good.
you so much for your time and the explicit presentation. My simple question is, if one has a will made, does it have a time, how many times you can change it in the course of within a year, or it doesn't matter?
No, you can change your will at any time, Toba. And I have a joke sometimes. Some of my clients will come in and they'll come in 3 or 4 times, and I always look at them and say, okay, who misbehaved today? Because they're always coming in, to change your will. And normally it's a matter of how you feel. And sometimes they'll change it because I said before, if you gave somebody something in a will, but then during their lifetime, you said, you know what, I'm going to give you $50,000 so you can pay down on a house, then you might just want to change the will to make sure that person, that's reflected and that person is not inheriting 50 plus sharing in the other assets.
Okay.
All right. One question in the chat. It says, does a power of attorney expire when a person dies? And the answer is absolutely categorically yes. Once that dies, power of attorney dies with you. The person has no authority at all to act once a person dies. You cannot act pursuant to a power of attorney. Okay, so the person says, one of the questions says, if a parent dies without a will, what happens to their house when there's an adult child living in the house? Well, whether or not the adult child is living in the house, that house is going to automatically vest in all the children, adult or not. And very frequently what happens is that the ones that's living in the house, they're not going to move, but that house literally vests, we say by operational law, so you technically automatically own the house upon death of the parent. So you'll be a co-owner. So what would happen is that what happens very frequently, and I've seen that happen on a number of occasions wherein individuals can't get one out, and they'll come in and they start what is called a partition action, wherein once one person's coming in as a co-owner saying, look, this one won't let me in, they won't do anything, in order to sell the house, so I'm coming in now, and I'm going to ask the court to force the sale of the house and split the proceeds accordingly. Any other questions? Okay. If the spouse signed a document that he will not lay claim to any assets, is that okay? That is sometimes okay, depending on how the document is drafted. Many times individuals will come in to a marriage with prenuptial agreements, and the agreement, if properly executed, basically each party is waiving rights to each other's estate. If the document is properly drafted, then normally what the court would look at, was there a mutual exchange? You know, one spouse gave up something and the other spouse gave up something saying they won't make a claim, that's totally fine. I think that's, you know, if indeed that's the case, then the spouses can enter into some kind of stipulation to that effect.
Just a lot.
Any other questions?
This is
Huh? No other questions?
No, thank you.
Okay, thank you very much.
well, thank you so much, Mr. Campbell. This is a lot to digest.
I know.
Well done. I have questions, but it's trying to formulate it and just to remember, because you've done so well that you've explained just about everything. And it's a lot to absorb. I really have to sit back, think about it, and see where my questions lie.
When you have the second session, we can answer some of those questions.
I think so.
Okay.
But a lot of this has really baffled me, especially when it comes to the spouse, where you cannot leave them out.
Correct. Correct. And that's where a lot of the litigation comes into play.
I'm sure.
A lot of litigation, because we have had situations where folks have actually lived together
Yes.
for 30 years.
Yeah.
And as soon as they die,
Yeah.
you know, and they've actually lived in the same house, and as soon as they die, then the spouse, the person who has been out of the picture will come up and say, well, I am the spouse.
Yeah.
And I'm the one with the rights. And that's where the you know, the tug of war starts. And that's where the vengeance starts, to be very honest with you. Because the one who felt that, you know, they were cheated all this time,
Yeah.
they're going to take revenge. And it happens very, very frequently, and unfortunately it ends up in litigation. And it's just very, you know, sometimes clients will come in and I'll say to them, I said, look, I said, you got a house? What do you want to do with the house? Don't leave the house in your will. Just transfer the deed. Because if you transfer the deed, it's harder for them to fight you than once you go to probate or will, then you have to notify the other spouse. There's no way you can get away from it. But if you just transfer the deed, let them take the initiative and sue you. And sometimes this, you know, because you got to put the money up. So transfer the deed outright, you can avoid some of that issue.
Okay. The life insurance. I've had life insurance, but I don't remember seeing anything there about burial. As others, I think I'm under the impression that this life insurance, once I pass, that someone is going to use some of that money to put me away, other than having to say, I need to have my own money for burial.
Yeah.
Well, no. You see, that's wishful thinking. So what I'm saying is that there's nothing on there that says burial. But if you leave it to the estate, or if you don't have a beneficiary, it goes to the estate. It goes to the estate. And in New York State, your funeral creditor, okay, is considered a prime creditor. They get paid first. So everybody else gets paid after the funeral creditor. So if you had, let's say hypothetically, you had $75,000 in your estate, and it goes to the estate because that was the extent of your life insurance policy, and your funeral was $20,000, that $20,000 gets paid off the top, and then the other 50, you know, I mean, the 55,000 would basically get spread out amongst your next of kin. But the funeral creditor is going to get paid first. But once you put a name on as a beneficiary, then it's up to that person as to whether or not they will voluntarily spend that money towards funeral expenses.
Okay, thank you.
All right.
Yes, sir. Are there any more questions? Mr. Campbell, Gem of the Bronx, or Miss Sadie has a question. Miss Sadie, you're being recognized. Go ahead.
Okay,
Unmute.
she's still on mute.
Yeah, okay. Now, if your spouse did not buy that house with you, okay, the house was bought on your own, can they claim portion of that house?
Yes.
Yes,
If they
because in death they can. If that was a marriage, you can basically come in and argue that it was premarital property. But in as far as death is concerned, they're entitled to share in that.
Who makes these rules?
a man,
Who makes these laws and these rules?
we have to change it.
Well, but wait a second now. When these rules were made, they wanted to make sure that the spouse who was
Was
supposed
being protected.
non-working spouse would benefit.
Right.
Now things have changed a little bit. That's
Children in the
where
mail.
the rules came from.
Yeah.
Yeah, they were trying to protect
Protect. Yeah.
the wife who was a non-working spouse to make
Yeah.
sure that the husband couldn't go out and just disinherit the wife.
Right.
You know what? I think they were trying to protect the male.
No.
Yeah.
Are there any more questions?
No. I just want to say thank you so much for that information. It was very, very valuable. And it just shows that, I mean, we as a people, we have to stay on top of those hidden gems. You know, we have to stay on top of knowing the little things that we don't think about. You know, we have to stay on top of that paperwork. You know, like that's why a lot of us suffer, you know, really, you know, in the end. It's not that we don't have the resources, but it's just that we just let them go. We just let them go, all because of these technical bits of information. And I'm very grateful that you are here. You know, I could also call you a gem.
Oh, is that what John said? Gem of the Bronx?
A gem of the
Sadie.
Bronx. Yes, definitely. Definitely. So I do appreciate
Why don't you
and-
just call him Father of the Bronx?
and
not old
I
enough.
want to thank Ms. Claude and the library committee for even initiating this session. It would just be great. You know, maybe we could do it again later.
Yes.
It is very important.
Yep.
I think most of us, we're all very grateful for this workshop. But I think most of us are almost shocked to hear some of the idiosyncrasies that are here. Because wow, I'm still baffled by some of these technicalities.
Yeah.
But yes, we might need to do this again. Who knows?
Yeah.
Okay.
Yes.
Very good. Whenever you're
Quite
ready.
enjoyable. Thank you very much for your time, Mr. Campbell.
Okay. Thanks for inviting me.
Everyone
And
else.
now they're looking for Mr. Campbell somewhere else. They said Mr. Campbell is not here. I said, don't worry, he's busy somewhere else.
Okay.
Yes. Okay, thank you. Thank you.
Very
so
good.
much.
Thanks a lot. All right.
Okay, thank
Okay,
you.
thank you.
I'm going to call you.
Okay.
Thank
Great.
you.
Thank you. All right.
Yes.
Good night, everyone.
Okay, good night.
Okay, do we have any other concerns? Any other concerns? No?
We have your number, sir. Can you tell us your number?
718-882.
Wait. Since remember this is being broadcast, so you may want to put it in the chat.
Oh, okay.
Yeah, because you don't
That's
want
our office number. So
you know,
that's
I mean,
a-
unless you want the entire internet community to have your number.
that's fine. It's out there.
That's his office number. Yeah, so that's okay.
Okay.
You know,
It's out there.
business. Mhm.
718-882-2681.
Okay, we got it. Thank you, Mr. Campbell.
Okay, all right, very good. Take care. Have a great evening, everyone.
Okay, bye. So long.
Okay, now.
Thank you. No
Okay.
more business. We'll call for adjournment.
Dr. Bug,
You have-
Nigeria.
Yes.
Okay.
Yes,
Go ahead,
Mr.
Ted.
James.
Dr. Bug just said this is being blood. Yeah, can you hear me?
Yes.
Yeah, Dr. Bug just said this is being broadcast, but the question is, I know at the beginning you said it was being recorded.
It's recorded.
I want to know when will it be posted, or if it is going to be posted to Facebook, the Facebook website, because I was trying to find the one from last month and I couldn't find that one.
Yeah. I know that I recorded the session. And I think that we'd have to speak to George as far as how you can access the recording.
Actually, Madam First
Okay.
Vice Chair, if I can answer that. So when it comes to committee meetings, what normally happens is once the recording stops, then it goes into the WebEx server. Once it goes to the WebEx server, it notifies the person who sets up the meeting, and 9 times out of 10, that's always George. So once he gets a notice, which is normally the next day, so for instance, if the meeting stops in about another 10 minutes, he's going to get a notice probably by the time it uploads to the server. He'll get a notice, which will be, like I said, depends on when he checks his email. Then from what he does from there is he posts it to the YouTube. He posts it to our YouTube page. So Community Board 12 has a YouTube page. That's what happens. For the full board meetings, those can be found on Facebook.
Oh, okay, so it's on YouTube.
Okay, so you could check with George,
Thank you,
I
Dr.
guess,
Buck.
tomorrow. Okay, so I'm going to end the recording now. Okay, Ms. Claude, I'm going to end the recording now.
Thank you. This meeting is being adjourned.
Okay,
It's now 8:20 p.m.
all right.
When is the next meeting?
Thank you all. Thank
Okay,
you all
goodbye.
for coming.
Next
Thank
meeting
you all
is
for
when?
participating. Thank you.
The next meeting is next month.